not going to stand between you all and lunch, so I'll be brief. The municipal gain is a very important and unique asset in the United States. We're blessed to have it in Connecticut. 1905, and some of the mayor, the only thing, Joe is going to go into great detail about it. Am I screwing things up? Yeah, probably. And then, the mayors are frustrated, and we're all frustrated. Here's this great asset that most states do not have, and it's an ability for the municipalities to use the polls for any purpose, which is a super duper idea. But unfortunately, there's a lot of opposition to that. But the mayors pointed out it's great for economic development, it's workforce development. Mayor Harp talked about it as a broadband tool, a tool in their municipality's toolbox. So we're hoping that will change. And Joe is going to be handling that on behalf of Ellen and the Office of Consumer Counsel and the State Broadband Office. Joe's been a lawyer with the Office of Consumer Counsel for 15 years, which seems incredible, but I'm glad he's been there. He's a fabulous asset. He's now litigating all the broadband dockets that we have, which is a relief to me. He's much better at it than I am. He also testifies in this building on many occasions and is a regular contributor to our legislative initiatives here. He brings great puns, wit, and good humor to all he does, and I'm sure that he will do so with his explanation of the municipal gain and its status in litigation. Joe Rosenthal.
I guess I'm talking from here. I was hoping to use one of the legislators' chairs. I was hoping to finally have that opportunity. But thank you to Next Century Cities. Thank you to the audience. Thank you to my delightful boss, Consumer Counsel Katz, for this opportunity to talk with you about the municipal gain. There's been some discussion of it already. What is the municipal gain? The municipal gain is a space on the polls, basically, reserved for municipal use. And as of a 2013 statutory amendment, it was added the language "for any purpose." So, we've been interested, as Ellen just mentioned, there are, and as Selectwoman Fowler from the town of Sharon mentioned earlier, there are areas of the state that don't have access to broadband. There are other areas of the state that don't have affordable access to broadband. It's a small state. It's a relatively wealthy state. We like to think of it as a high-tech state, so OCC is interested in solving that problem, and we feel, and we also have the statutory mission now through the State Broadband Office to help to solve that problem, so why not solve it? So we've been working with municipalities interested in trying to use the municipal gain to develop broadband for the public. As far as I know, it's a unique asset nationally, this reserved space on the polls for municipalities called the municipal gain. In other areas of the country, they have very large municipal electric companies, so not everywhere, but in many parts of the country they do, and that creates different issues, but you have municipal ownership of the polls, so these issues don't come up. But here we have this, a potentially useful asset. So we saw the "for any purpose" language in the statute, and we're talking with municipalities interested in using the municipal gain to develop broadband and for their constituents, for the public, and but they were having issues with some of the pole attachment agreements with the pole owners. Some of the pole attachment agreements hadn't been, in our view, modernized to allow this usage, so they were having those struggles. There were also issues around the make-ready process, and there had been a PURA ruling already that even though the municipal gain statutory language says without payment therefore, that they could still be held responsible for make-ready costs. And we at OCC took that as a given, but we also pointed out that if there's a failure to reserve the municipal gain, arguably those make-ready costs should be limited based on a failure to reserve. So we wanted to make, we played some patriotic music in the office, did some Jimmy Stewart impressions, and decided to go into PURA to solve these issues. And we, obviously thought we had some pretty good statutory arguments and some good policy arguments. So that was started in, so the 1606 means it started, and I have it there, June 2016. So then, lawyers always win, right? So what happened was we faced some opposition from incumbents and others, the unions too at times, and they raised sort of the threshold issue. They said, well, you know, OCC, your filing sort of assumes through the for any purpose language that municipalities really can use the municipal gain to provide broadband services to the public. And municipalities, by the way, have been using the municipal gain for internal communications, including using fiber. The most prominent example is Manchester. But this is not about that. This was about trying to use it for broadband service provision to the public, to the businesses and citizens in the relevant municipalities. So, but they raised the threshold issue. Are you really sure that that's what the statute means? And as I mentioned, the for any purpose language came into the municipal gain statute in 2013. It was in a giant budget act. As we've admitted and acknowledged, there's little to no legislative history on that provision, and it replaced a reference in the statute to for municipal and state signal wires. But again, even under that for municipal and state signal wires language, it was felt that, and ruled on by PURA, that municipalities could serve internal communication purposes using the municipal gain. But again, we wanted to use the for any purpose language to extend that one step further so that they could use it to solve the larger problem. A sub-issue also arose about, okay, even if a municipality could use the municipal gain for this purpose, can they make an arrangement with one of the many entities that are, you know, working around the country, you know, with municipalities in Kansas City and Chattanooga and Louisville and other places to help them? So can they not only use the municipal gain themselves, but can they make commercial arrangements with some of these third parties to accomplish this end so that they don't have to hire all of this talent to get this job done? All right, so we filed the declaratory ruling request with PURA to try to resolve that threshold issue of what does for any purpose mean. And we got a draft ruling last summer that went against us and said that no, despite the change of the language in the statute, municipalities continue to be limited to being able to use the gain for internal municipal communications purposes only. But by law, PURA had to finalize that ruling within 180 days, and we took exception, our allies took exception to the draft decision. And, you know, it sort of popped in our head on days 174, 175, that they may miss the deadline, and they did. So when that happened, that draft decision died, and since it went against us, we weren't terribly sorry about that, and it sort of restored the status quo. But then some of the incumbents decided, well, we liked that declaratory ruling, so you know, we're going to try to make that finalized. So that became the September 17 declaratory ruling. So they turned around and filed the declaratory ruling request, and PURA again ruled in their favor that yes, that the municipal gain is limited to internal municipal purposes. The reasoning was very different and more, I would acknowledge, harder to deal with in the litigation that's following. So in any event, and some of you really sharp people might notice that there's, from September 2017 to May of 2018 is more than 180 days, but PURA pushed the deadlines, just in case that was bothering anybody. Okay, so what did PURA rule specifically? They said that the statutes, for any purpose, you know, three English words in common parlance, but they nevertheless argue that they are ambiguous. as to whether it allows broadband provision to the public. They said that they must choose a course that is not constitutionally precarious, and then they pointed out that there are federal law provisions which call for fairness in broadband competition, and Pura viewed that they had responsibilities to not allow municipalities to use what is a free space, at least by statute, but there's a longer story there. And they argued that that would create, that allowing the municipalities to have a free space on the pole where others may have to pay for the pole would create an unlevel playing field. And by the way, unlevel playing field was ruled the most overused trope in 2018. The 2017 winner was pick winners and losers. Anyway, so that's where they landed. Yeah, so they said that, they also said, in addition to the federal law, they said state telecom competition law would be violated by allowing municipalities to have so-called preferential access to the polls. So what did we do? We sued. And so we filed administrative appeal along with our allies, many in this room, Connecticut Conference of Municipalities, various towns and cities, and there's 3 separate appeals. The parties are in different groupings to the Superior Court. They've been consolidated. We focused on the legal errors. The towns have also raised that some due process concerns because they didn't feel like they had the full opportunity at Pura and proper notice to make their arguments, and also jurisdictional errors by Pura. We filed our briefs on October 31st, so I'm just coming off of that immense effort with my colleagues. And we get responsive briefs, and then the ruling is probably not going to be until the spring. That's a rough guess. It's almost certain to be further appealed, regardless of who wins. So you're looking at, in all likelihood, Connecticut Supreme Court, and so we're probably not ultimately going to get a ruling until at least 2020. So that's a problem. So, so among other things, what did we argue in our brief? I've hinted at some of this already. We said, heck, for any purpose should mean for any purpose. It's unambiguous language, and so under Connecticut has a plain meaning rule for statutory interpretation, so we said, that's how it should go. We said that, okay, because towns like Manchester already had a clear right as of 2000 to use the municipal gain for internal purposes only, a ruling that despite the statutory amendment to for any purpose, they still only have a right to use the municipal gain for internal purposes, nullified the 2013 for any purpose amendment. So we made that argument. We also refute Pura's claims to have responsibilities to protect telecoms communication because of the early 2018 FCC order, which again said that internet services are information services and they're not telecom services. So, even though we otherwise weren't all that delighted by that order, we decided to. It's the law, so we decided to use it in the brief. Very importantly, there was no evidence taken by Pura on the alleged impacts on competition from municipalities using the gain for broadband services. They just said that it would negatively impact competition. So we made that argument that at a minimum there should be a remand. But the bad news about a potential remand would be that the timelines that I gave you earlier in this speech would be extended out yet further. And we also made arguments under the Home Rule Act, and our co-plaintiffs made additional arguments, as I mentioned previously. So wrapping up, again, we thought the 2013 statutory amendment was abundantly clear, and that's been the focus of our argument. But we're not going to, I mean, if for the municipalities in the audience and others interested, this is not going to get resolved finally until 2020 or 2021. So if you need something faster than that, and for my, any litigation opponents I have in the room, even though this statute is abundantly clear in our view, it is possible that through the legislature you could try, including in the upcoming session, to make it yet clear in perhaps the language that I have laid out there, to get exactly what you want faster. And we would welcome that as well. But, when you open up a statute, other people will also have views about how it ought to be revised. So that's always the intense danger of doing that. So that's all I have. Any questions pop up?
Thank you. Question. In most states, pole attachment costs are a minor cost. Why does it matter so much in Connecticut?
I realize that was ambiguously worded. What I meant is pole attachments after make ready.
Right. It has been discussed at times, in other words, why not just acquiesce in the pole attachment expense? Is that what you're driving at? Well, that's not my call to make. I mean, it's the municipality's call to make. The statute at this point says without payment, therefore, if that's the strategy, I suppose that could be a legislative strategy where if that's the rub, right, maybe it's not important enough to continue to be the barrier. But to me, that's really their call to make in terms of legislative strategy. Yeah. We've heard it before.
Okay.
Joe, thank you very much for coming and giving that presentation you just gave. The far-out scenario of resolving it in 2020 or 2021 makes me think that's if it was to be completely resolved at the Connecticut Supreme Court level. What are the odds that, given the magnitude of the companies we're talking about, it would go beyond that?
Wow, fantastic question, and one that I've thought about only a little. But yes, I mean, some and based on some of the arguments that we ourselves have made, it sort of would lean people to say maybe some of this belongs in a federal litigation setting. So in addition to, or perhaps someday as an alternative to Connecticut legislation, maybe there will be, if the municipalities are permitted to use the gain, would that generate a complaint to FCC? Potentially it could. I don't, but so it's, yeah. So, but there's nothing we can do about that within the state. I mean, we can, but it's not up there anymore, but, we can tighten up the statute yet further. But if someone goes ahead and makes a federal claim, we'll just have to live with that. Now, Connecticut does have, many in the audience will know, Connecticut does have responsibility for its own pole attachments under the reverse preemption, but there's nuances there as well. Oh, I'm not supposed to be direct. There's one over here for later.
Following up on that most recent point, you mentioned there were limitations to reverse preemption. What do you think would be in play there?
All right. Well, I have a copy of my brief, but the 47 U.S.C. 224, which deals with that issue, refers to connections by cable companies and for telecommunication services. And if you're going to follow through with the stance that internet services are information services and not telecom services, one can make the argument that 47 U.S.C. 224, through which we get our reverse preemption rights to pole attachments, may not have applicability. And there was an 11th Circuit case, reversed on other grounds by the Supreme Court, that sort of went some of the way down that path years ago. Yeah.
We're going to make this one the last question.
All right.
What if a municipality just went ahead and used the municipal gain for broadband provision? Maybe it's worth the risk?
Maybe, but they, well, you know, and it's well, okay. There's an interesting point to that question, because Manchester, you know, sort of this, you know, the most significant example in the precedents, was sued, complained about to Pura by the former SNET, claiming that they were doing just that, that they were using what they claimed would be a municipal purposes system to provide it also to the public. And it's interesting, and this is the 2004-2005 time frame, and Pura said, we don't have any jurisdiction because those are information services. Okay, so it's part of the argument that we make in the brief. They could try, but I mean, you know, there are serious folks on the other side, so with some excellent lawyers. So they've, you know, so it would be an expensive proposition.
Thank you.
All right.
Thank you.
Okay.